you know that you can appeal a court's decision in a child custody, divorce, or DHR defense case in the middle of the case? Now, it's not technically called an appeal. It's called a petition for writ of mandamus. Now, that's a lot of words, that's a lot of Latin. And the reason we're talking about it today for you church folks out there is it's actually Maundy Thursday, which comes from the Latin mandatum, which is also the Latin root of where we get the term petition for writ of mandamus. It's an order from the Court of Civil Appeals or from the Supreme Court ordering the trial court to do what it's supposed to do. So this comes up a lot in divorce cases during what they call pending light alimony. If one party or the other has to keep up certain financial obligations during the marriage or during the divorce case, which can last months, if not years. This comes up a lot in child custody cases, in which there is some sort of pending light or pending the litigation order that, okay, this is going to be the custody situation while we investigate the case, while we gather evidence, while we prepare for trial. If a court enters a ruling at a stage like that, or a ruling on a motion for summary judgment, or any other interlocutory order, that just means intermediate. That means not at the, like before the case is completely over. That's when you appeal. But you can file a petition for writ of mandamus at any point during the case based on what you believe to be or what the law may deem to be an incorrect or errant decision of the trial court. Now, these petitions for writ of mandamus, they're toss-ups at best, and it's not something you can do without the help and assistance, service, and support of an experienced not only family law attorney, but one who's well-versed in the appellate process. The mistake we see a lot is that people file motions to reconsider before filing their petition for writ of mandamus. That doesn't exist for interlocutory orders. You've just got to file your petition for writ of mandamus. You've got to file it within the time normally allowed for an appeal. That's 14 days for juvenile court, 14 days for CS court, which is actually a case designation of the juvenile court. That's 42 days for a DR action in the circuit court. So, guys, if your case is going to be lengthy and there is an adverse order at some point in the middle of the case and it's just wrong, or it just doesn't comply with the law, or it doesn't protect the interests of your children, or it's not fair to you and the legacy you've established for yourself during the divorce process, you have appellate rights through what's called a petition for writ of mandamus. So in honor of Maundy Thursday, in order of the mandate that we have to bless others as we have been blessed in this life, remember the option to file what's called a petition for writ of mandamus. It's a toss-up at best. It's a complex process, but when it comes to your children, when it comes to your legacy, when it comes to your day-to-day life, and being able to stand up for yourself in the legal process and get a second look at what the trial court either just plain got wrong, or maybe they missed something, you have an opportunity for a second look from either the Supreme Court or the Court of Civil Appeals based on the circumstances. So don't hesitate to discuss with your lawyer or reach out to our team to explore your options, even if you're in the middle of the case and want to consider a petition for writ of mandamus.